Anymore. There's holes in the roof and dirty water on the floor. We said you come by and fix it on time, and we've heard that before. So we ain't paying rent to you putzes anymore. We ain't paying.
My name is Jackie Barkley, and I think I was asked to chair tonight because I was able to tell Shay to be quiet so we could get started. I think that's the only criteria. Welcome. I'm a social worker. I have been for many years, and I'm retired now. But as an individual and as a single mom, I'm still a single mom, but at one point when I was actively a single mom parenting, and before the cooperatives of the federal government in the early 80s, I rented for about 20 years, and it was difficult, and it was a crapshoot, and you were lucky if you got a really good landlord, and if you didn't, it was difficult and frightening. I have some memory of that. Because of the cooperative federal government funding that existed in the 80s, which no longer exists at all, was possible for even some of us who were single parents and some of us to be able to get into cooperatives and get decent housing conditions, and for some of us even to save enough money to get a house in the days when it was possible to buy them, which is no longer the case. So, I don't claim to know the struggles that people are waging now around these issues, but to have a small little bit of experience and to know in the work that I do that housing is the single biggest issue that people struggle with, getting good, decent, affordable, accessible housing. So I'm just very honored, aside from the fact that I know how to tell Shay to be quiet, and I was invited just to chair this evening. So the first person I would like, the way the evening will go is there's going to be some speakers for about 8 to 10 minutes. We have 3 speakers. And then there's going to be an open discussion, questions, answers, discussions, opinions. And after that, some action issues that are going to be raised. Is anybody uncomfortable with the fact that you might be filmed with global? I just want to be sure that, no disrespect to you, that people are excited. All right, so just so no one objects, it's important that you know that there's
I was born in front of the camera.
All right, thank you. The first person who's going to speak is Evan Cool, to my right. Evan was involved as a founding member of Nova Scotia ACORN, and he helped to launch the campaign for rent control. He's a former provincial organizer and a current leader in the Halifax Regional Municipality chapter of ACORN.
Well, thanks, Jackie, and thanks everyone for coming. I'm going to be talking mostly about rent control, but before I do that, I'm just going to tell you a bit about ACORN. ACORN is the Association of Community Organizations for Reform Now. We're a national organization of low and moderate income people. We have 55,000 members in cities across the country. We're new in the HRM, but building, and it's quite clear, well, as I'm sure everyone who showed up tonight knows, it's quite clear that we need an independent voice for tenants in Halifax, for low and moderate income people. And I hope you'll all consider getting involved. ACORN works by harnessing the numbers of people affected by an issue. So we plan campaigns, we win victories for working low and moderate income people. We've seen victories in Toronto with the enforcement of the housing standards bylaw. As a result of our activities, that's now quite beefed up. We've won victories in terms of getting a housing bylaw in cities like Burnaby and New Westminster. We've also worked on living wage campaigns to regulate the payday loan industry. all issues that are very relevant in Halifax. Tonight I'm going to be talking about rent control. When I worked as the organizer for ACORN, probably affordability of housing was the most consistent issue that people were raising, and as a renter myself, this is something that I struggle with, finding an apartment that's actually affordable as well as a place that I want to live in. Contrary to a lot of the journalists who've been, the points that journalists who've been interviewing me have raised over the past couple of days, rent control actually works. We had it for a number of years in Nova Scotia. It's also in place in Ontario, British Columbia, Manitoba, and Quebec, where it works great. It ensures affordability in housing and prevents cash grabs by landlords. It's possibly one of the best and most cost-effective ways to provide affordable housing. And the reason it doesn't exist in Nova Scotia anymore is not because of ineffectiveness, not because it was a bad policy. It was removed by the Savage government with absolutely no democratic debate. For those of us like me who aren't experts in parliamentary procedure, I had to get an education from Megan Defoe, who is in the audience from Dow Legal Aid. But there's something called an order in council, which would be when the cabinet of the ruling government makes a decision around legislation. This is how rent control was removed. The Rent Review Act is still on the books in Nova Scotia. It was decided by the cabinet of the Savage government that it no longer applied to residential properties. So it still exists, just doesn't apply to anything anymore. I don't get it either. So I think that's been what's been most frustrating about this campaign is that we aren't really asking for anything new. We're asking for a mistake of a previous government to be corrected, and very few politicians are willing to bite on it. I think another important thing to mention here is that there is a very strong and powerful landlord lobby in Nova Scotia. The Investment Property Owners of Nova Scotia serve as a voice for landlords in policy matters, in the public sphere. I don't know the specific history there, but I think it's not an unreasonable assumption that it might have been the landlord lobby who pushed for this to be gutted as opposed to, well, let's say rational and reasonable consideration of what policy works for housing. What else did I say? Another point that I really wanted to mention too, something that keeps coming up when I talk to folks about rent control, especially decision makers, is that we don't need rent control. What we need is more affordable housing. That, well, how can I be respectful about this? So if you're going to ensure affordable housing, regulating the price of rent would seem to me to be a pretty intuitive way of doing it. We do need more affordable and supportive housing, but as a start, rent control would be, or reinstating the Rent Review Act rather, would be probably one of the most solid first steps we could take. Let's see. Just have to check my notes. I'm honestly not sure there's much more I can say because it's just, once again, very intuitive to me that this is something that Nova Scotia needs, it's something we should have, and it's something that a lot of people have been talking about. We are in an election time, and in addition to the landlord lobby, I think we should be looking at what candidates are on our side, what candidates are saying, and hopefully after tonight, when we get into talking about what actions we can take, we'll actually get some support from candidates. I would like to point out, though, that there's not only a lobby, there are, at least that I know of, 3 landlords running in this election. 2 of them for the Liberals, 1 for the Progressive Conservatives. And of these, one does have properties on the bed club registry. She's the Liberal candidate in Halifax Armdale. Her name is Lena Diaz. And I think it would be interesting to hear what she actually thinks of rent control and strengthening tenants' rights. To talk a bit about well, I'll let Jackie introduce Bruce, but there's a whole other side to this with the Residential Tenancies Act and the actual legal processes that exist for tenants. So I think now would be a good time to turn things over.
Thanks, Evan. Bruce Muir is a law student, and he just did his summer term at Townhall Legal Aid. He's a member of the Social Activist Law Student Association, and he is the law school's queer rights group, with the law school's queer rights group Outlaw. Thank you.
Okay. So I'm going to give you an overview of the residential tenancy system and some of the problems with it. So I'm not a lawyer, and this is just legal information. The process isn't perfect, but it's there, and it's meant to be accessible. So where do your tenants' rights come from? They come from the legislation, the Residential Tenancies Act. You can get a copy online, and the landlord is also supposed to provide you a copy with your lease. So are they actually rights? We can look to the legislation to get an idea. So if you look at the purpose of the act, it says, the purpose of this act is to provide landlords and tenants with an efficient and cost-effective means for settling disputes. So when I read that, it's not really the most empowering phrase that I've seen in legislation. It's just, the system we have now is a slightly more regulated version of the old contract-based landlord and tenant law. And that came from the feudal system, because you can tell we still have the term landlord. But we still do have minimum standards in every lease, and they can be seen as rights. The rights will only have a practical effect when a wronged tenant has the time and the resources to exercise the rights. Or if they're super lucky, they might have money to hire a legal representative. So I'm just going to go through some of the rights that are contained in the Act, and I'll try to go as fast as I can because it's a very big Act. So one of the landlord's obligations is to keep the premises in a good state of repair, and he's supposed to keep it fit for habitation. He's also supposed to keep the premises so that they comply with laws respecting health, safety, and housing. These standards aren't the best, but you have to have running water in the city and stuff like that, and electricity. The tenant can't the landlord can't withhold consent when you want to sublet, and he can't charge you a fee unless expenses are actually incurred. There's a maximum $75 fee for subletting. You can't enter your premises unless he's already given you a notice to quit, and he enters during reasonable hours of the day to show the place to prospective tenants. Otherwise, he can only enter if he gives you 24 hours notice or if it's during an emergency. Also, you can't change the locks without consent. So now I'm going to discuss how you end your lease and how the landlord ends the lease for you. So first I'll talk about the notice to quit. A notice to quit is just a piece of paper in the form prescribed by the regulations, and it's given by the landlord to end the lease in limited circumstances. Because today, there were amendments like a couple years ago that gave tenants immediate security of tenure. This doesn't mean that you can just stay in your apartment and do whatever you want. There are certain circumstances when the landlord can kick you out. The counterbalancing factor here is you have security of tenure, but you also get locked into a lease. A year-to-year lease will go, you'll have to notify the landlord whenever you want to end your lease. So the landlord has rights too. So now we'll talk about when the landlord can actually get you kicked out of your place. So if you're in arrears for 15 days, the landlord can give you a notice to quit. And that doesn't have any effect. The sheriff can't come and push you out if you just get that piece of paper that says notice to quit. So that will say you have 15 days to either pay the landlord back or apply to the director to dispute the fact that you're in arrears. So you're in arrears for 15 days, then there's another 15 days for you to dispute it. And then after those 15 days, the landlord can go to the residential tenancies director, and the director can issue an order without a hearing, and then they can kick you out. So an order will have the power of the law, and the sheriff can come and try to get you out of the premises. So other than arrears, there's only a few other situations where the landlord can kick you out. One situation is if you have a fixed term lease, every time you renew that lease, you have to get consent of the landlord. If your place burns down, if you don't obey the statutory conditions, but usually the landlord will have to go to the residential tenancies board to actually get an order to kick you out. Or if he in good faith requires the premises for repairs. So how do you end your lease? If it's a year-to-year lease, you have to give notice to the landlord, and you always want to give notice in writing and in the form prescribed by the regulations. So if it's a year-to-year lease, you want to make sure that you give your notice 3 months in advance. If it's month to month, you want to give your notice to quit 1 month before the end of each. You have to give it 1 month in advance. If it's week to week, you have to give it 1 week in advance. There's other reasons why you can end your lease early. If you have a reduced income because of a health reason. Another one is something in the premises is something about your apartment causes you to be sick. You can get out with 1 month's notice to quit. And if you're moving into a nursing home, you can get out with 1 month. And domestic violence. And all these reasons, you need specific types of evidence. So for the something about your health, you would have to get a doctor's note, and you would have to fill out the correct forms. Same with the domestic violence one, you would need a certificate from the from the Director of Victim Services. So one of the things that works with the notice to quit is you have 3 months on a year-to-year lease to give your notice to quit. So the landlord has to give you notice about a rent increase 4 months before the end of that lease. So basically you're given a month to kind of think about, okay, they just increased my rent. I have a month to say whether or not I want to move out or not. Rent increases, there's no limits on how much a landlord can increase your rent, except you can only increase your rent once per year, unfortunately, by any amount. One thing to keep in mind is a discontinuance of a service does count as a rent increase. So if he increases your rent and then later during the year, there was a communal kitchen he decided to cut down or just stop letting people use it, that would count as a rent increase. Or like a pool. Not that anyone has a pool in their apartment, but if you did, and he cut off access to that, that counts as a rent increase. And he can only do 1 rent increase per year. So those are the basics of the rights. How many minutes am I?
You're fine.
I'm good? Okay. So the next step is to gather evidence. So always correspond with your landlord in writing. And always take photos and never pay in cash for anything. And you always, if you're going to apply to the director, it's just evidence. You want to have as much evidence as possible, so you want to consider potential witnesses who might come to your hearing, like neighbors, and stuff like that. So the next step is to get help. So you can call the Dal Legal Aid Tenants' Rights Hotline at 423-8105. There's tenants' rights guides over there that should have the number in it. You can also walk into Dal Legal Aid during the day. and a senior law student can give you some information. You can also call the Legal Information Society of Nova Scotia. So to apply to the director, you fill out a form, and then you have to serve your landlord with that form too, and then you get these forms at Access Nova Scotia. And so you get your form, you serve it on the landlord, you come back to Access Nova Scotia and you fill out another form proving that you've served the landlord. The next step, the director will try to settle something. So instead of him issuing an order, he'll try to work out the problem between you and your landlord. And if that doesn't work, there's a hearing, and you will just argue your case. It's a very informal setting. So it's supposed to be very accessible, so you can just go and bring all the papers you have an idea of what's wrong. Like, even if you don't have an understanding of the law, but you just feel wrong, it won't hurt to go. So the director can issue an order within 14 days, and that can require the landlord to comply with the Residential Tenancies Act or pay money, make repairs, etc. And if you don't get what you hoped for, and you have the energy, you can appeal to the small claims court. And after that, if you lose again, and you have a ridiculous amount of energy, you can appeal to the Supreme Court of Nova Scotia. So that's the basics of the process. So I had problems with the legislation. Does anyone have any questions about the process?
You were talking about reasons why you can get out of your lease. What are some of the medical things that a doctor will sign off on as
I can think
something
of,
break a
well,
lease?
I haven't actually had any experience with it, but my guess would be like, if the
So
wood
I
and the...
have, and was refused because I had bed bugs, and it actually sent me into like a really messed up depressive episode. And they were like, no, you have to basically be carried away in a stretcher before.
Did they say that at the...
As the doctor said.
Oh,
this.
the doctor said that.
It was messed up. It's okay if you don't know.
I don't know, do you know? What would you say?
Two reasons. One is that you've had a reduction in health that has affected your ability to earn the same income. Like your income's been dramatically reduced. I can't remember the exact wording.
One of them is the
And-
premises makes you unhealthy,
Yeah.
and the other one is your health makes you earn less money.
Yeah. Well, or also that it's not that the premises makes you unhealthy, although that would be one, but it's that your change in health means that you can't use that place. So the classic example they say is if suddenly you're paraplegic and you're in a 3-story walk-up with no elevator, then you can't live there, right? So but I can't remember the exact wording. But the doctor doesn't have to put down your diagnosis on that medical form. That's private information. The doctor just has to say that whatever you have a condition.
So basically you need a good doctor? Is that what you're saying?
I mean, basically, the doctor doesn't have to tell the landlord what your medical condition is. They just have to tell the landlord that you have a medical condition that means you can't live there anymore. So I don't know what your doctor is.
He's a dick.
Can I just,
sorry,
can I just ask you just to hold the questions for
Yeah.
a minute, just to sort of wrap things up, and then we'll open it up to the floor?
Okay, yeah, sure,
um,
yeah.
For all questions. Are there
So
other things that you
I have some
want?
problems with the Residential Tenancies Act.
Okay.
I'll go to that. Okay,
I'm
so,
not trying to cut you off, I'll just come back, all right?
okay. So one of the main problems with the Residential Tenancies Act is that tenants can't claim together. This creates a problem because if they could claim together, it would be more likely that people would actually work together and pool their resources and build their evidence and build their case with everybody in their apartment because and they'd have a better chance of winning. But unfortunately, the way the Residential Tenancies Act is set up right now is each tenant has to apply individually. And another problem is it creates this imbalance because the landlord can kind of see who's applying and the landlord has this all-seeing eye, right? And he knows who's applying. He can try to settle with each individual tenant before there's an outbreak and word gets out that that there's this problem in the apartment building. So that's problematic. So what a good reform would be to have tenants be able to join together. There is a bill in Parliament legislature right now, and it's not been passed. It's a private member's bill, and it would allow tenants to claim jointly. Another problem is that the director's orders are only ever really going to be enforced between the individual tenant and the landlord. So if a tenant doesn't complain, even the landlord can treat each tenant kind of differently. If, say it was a problem that was universal to the apartment, like say the whole apartment, he discontinued his service in the entire apartment. So what will end up happening is only the tenants that come forward will get a remedy, and all these other tenants in the building will just be wronged, and there's nothing they can do about it unless they know about the problem. Yeah. Another problem is that the landlord gets a security deposit up front. This is problematic because they can just kind of take that security deposit, and if you don't dispute it, they can just use it. So what we want to see happen is have Access in Nova Scotia take your security deposit, and there's an equal onus on the landlord and the tenant at the end of the lease. And so if the tenant wants it back, they'd have to apply to Access Nova Scotia, and the landlord would have an opportunity to say, no, this bad thing happened, and they would have to go prove it to the residential tenancies officer that I want this money for this reason. But right now, the way it is that the landlord will just take it, and the onus is on the tenant to go to the residential tenancies board and prove that the landlord is wrong. And so that's a problem. Another problem that is associated with residential tenancies is the fact that you can't appeal to the Nova Scotia Court of Appeal. So it goes residential tenancies board, that's the first court. The second one is the small claims court, and that's the Supreme Court of Nova Scotia, and then it's the Court of Appeal. The problem with that is that there have been cases where human rights issues have been decided at the tenancies board or at the tenancies level, and it's just it's disheartening to think of the idea that a human rights issue could just be decided at this low-level court. Not that it's a low level, it's high, but human rights issues are important, and we want to see them decided at the highest possible level with the judges with the most experience. So that's another problem. And the solution to that would be to amend the Small Claims Court Act. Yeah. Okay, I'm done.
Thank you, Bruce. So
Okay. I'm going to ask something that's probably a no-brainer. Who do you think has more money, your landlord or you? When you go to the tenancy board or take it to small claims court, or do tenants end up at the Supreme Court, who do you think has the advantage, you or your landlord? Landlord.
Unless Bruce is representing the Supreme Court.
You're right, and I should be giving due respect to the law students, lawyers, and community legal workers who are on tenant sides, but for the most part, the legal system is stacked against tenants. ACORN believes that we need a political voice as well as support navigating a system that's stacked against us. What ACORN does, it's useful to think of us as a community union or a tenants union. What we do is unite people. We're a membership-based organization. We're based on the principle that we're stronger together, and that by pooling our time, energy, money, resources, by doing all that, when we come together, we can actually have a strong political voice that can make meaningful change for low and moderate income people and tenants. For starters, in terms of action, I'm going to throw out a couple of things and we'll see what you think. We are going to be circulating an open letter to candidates in the provincial election, making 3 immediate demands of the next government. bring rent control back to Nova Scotia by re-implementing the Rent Review Act, revising the Residential Tenancies Act to allow tenants to file a collective complaint against their landlord, and provincial support for enforcing municipal minimum standards bylaws to ensure the health and safety of tenants. If you haven't signed this yet and agree with the content, please come to Shay. We also are providing information, contact information for all of the candidates in the HRM. Talk to your candidates because they are talking about tenants' rights, and I think we have to make them. And finally, perhaps the biggest item that we're calling for is a day of action to make the next government implement these demands. We're calling for a day of action on Thursday, November 14th at 1 o'clock outside of the legislature. And that brings me to the final point, that in order to make all of this happen, we really do need to come together. We need to unite. I'm going to make a pitch that for those of you who aren't already, that you consider joining ACORN as a full member. This will give you the ability to serve in leadership roles, to vote on your leaders, and basically it gives us the ability to have a democratic political voice that can represent our concerns to government and speak a little bit of truth to power. So I'd be really interested in your thoughts, like, do you think this is a good start? Would you be willing to sign a letter? Would you be willing to contact your MLA?
I've done it before for Metcalf, I called an MLA. And then other housing issues came up, and it wasn't my initial call, but yes. I will.
So, show of hands, who's willing to sign the open letter? Shay, do you want to circulate? We'll have that around. Who's willing to call their candidates? Fantastic. Their contact information is around that. And who would be interested in coming to a meeting to talk about how we can organize for tenants' rights? Fantastic. Okay, so what do people think? What do you
We ain't paying rent to your putzes anymore. There's holes in the